Good morning or good evening, ladies and gentlemen, depending on where you are. Welcome to this Six Pump Court webinar dealing with the impact of sanctions, economic sanctions on international arbitration. I should begin by telling you that the webinar is being recorded. I'm Andrew Moran, King's Counsel, a full-time arbitrator and an associate member of Six Pump Court Chambers. I'm based in Singapore, arbitrating in seats east and west of here. I'm relieved of the duty of pontificating to you this morning about the potential impact of sanctions on arbitration by dint of the fact that I'm currently appointed in 3 references in which the impact of sanctions is an issue in different ways. I tell you that because it illustrates well that this is a hot topic of increasing importance, with sanctions imposed by states and supranational bodies impacting increasingly on all participants in arbitrations, parties, counsel, arbitrators, tribunal secretaries, and in certain circumstances, even witnesses who might be aiding and abetting sanctioned parties to flout sanctions in pursuit of remedies in arbitration. We have 3 speakers this morning. I will not recount their impressive CVs as they are summarized in the flyer that you have for this webinar. They will deal with these issues on something of a world tour as follows. You'll first hear from Paul McGarry, Senior Counsel of the Irish Bar, Counsel and Arbitrator. He will give you an overview of the EU regime and the sanction measures in place in EU jurisdictions, covering how they work, with comments on the regulations themselves, then illustrating their impact on arbitration and commercial transactions generally, and then explaining the practical issues that they give rise to for lawyers. We'll then move far to the south and east, to Southeast Asia and Australasia, to hear from Stephen Walker, King's Counsel, also counsel and arbitrator, who will give a broad overview of the impact of sanctions as he sees them in his region, with particular mention of retaliatory measures adopted by the state targets of sanctions, sometimes called pushback or blocking measures, such as have been adopted by China, for one notable source. We'll then circle back to the United Kingdom to hear from Daniel Martin, partner with HFW, Holman Fenwick Willan, for those who've known it a lot longer than HFW, here in London, and we welcome him particularly at Six Pump Court as members of Six Pump Court, and thank him for his participation with us in this webinar. He is a specialist in dealing with the effects of sanctions in the UK and elsewhere. He will deal particularly with the UK framework, enforcement of sanctions by the UK to date, specific restrictions on Russia, Russian entities and persons. He will speak to general licenses already issued, the Solicitors Regulation Authority guidance, and issues for lawyers as they arise in the UK. There will be an opportunity for questions, which we will take after the presentations. Please use the Q&A facility on the Zoom platform as you see fit. I will endeavour to pick out as many testing questions as I can find to put our speakers on their mettle. And please don't be offended if I should not alight on a question that any of you may have asked. I suspect we'll have too many interesting questions to deal with in the time available. So let me hand over to Paul McGarry to begin with the position in the EU. Thank you, Paul.
Thank you very much, Andrew, and it's a pleasure to have the opportunity to speak to you all again, and hello to all my colleagues and friends at Six Pump Court and wider, and good morning or good afternoon wherever you are in the world. looking at the list of attendees, it seems like we've got a fairly wide spread. What I'm going to talk about, as Andrew said, is the situation as it pertains in the EU. I'll talk a little bit about the measures themselves and how they work. Have a look at commercial transactions generally and the impact on international commercial arbitration, and then come back to some practical issues as they arise for lawyers. So as we know, sanctions are defined as restrictive measures imposed on natural legal persons and states. They include, but are not limited to, restrictions on finance, trade, travel, civil aviation, and so on. Financial sanctions emanating from the EU are contained in sanctions lists. Member states don't impose sanctions unilaterally. All natural and legal persons under member state jurisdictions are obliged to comply with sanctions, and it's a criminal offence in each member state to breach or participate in any breach or try to circumvent the sanctions. And I'll come back to that when we look at the various provisions of the regulation. So the regulations themselves, and here I'm focusing primarily on Russia because that's the topic du jour. Although in fairness, the same structures operate by the EU in other areas and other parts of the world, Venezuela, Syria, Yemen, and so on. The principal regulations date from 2014 following the illegal annexation of Crimea and the subsequent war in eastern Ukraine. And the way in which the EU regulations operated, there are effectively basic regulations, and they are then amended from time to time by the Council by adding either sectors or individuals to the lists that are contained in the annexes to them. So the two principal regulations are 269 of 2014, which is known as the Identified Persons Regulation, and that's the regulation that contains the list of persons and entities. And 833 of 2014, which is the wider sectoral regulation, which refers generally to Russian entities, and then specific industry sectors such as coal, minerals, and so on. As I said, there are others. There are basic regulations relating to persons and individuals in Crimea or in Donetsk. There are also earlier regulations relating to Lukashenko and Belarus, and they all contain broadly similar measures providing for asset seizures, asset freezing, and so on. So just some comments on the regulations themselves. They're characterized by the use of very, very broad definitions. So Article 2 of Regulation 269 says, no funds or economic resources can be made available directly or indirectly to or for the benefit of natural or legal persons, entities or bodies, natural or legal persons, entities or bodies associated with them as listed in the annex. And the annex, as I said, contains the list. And Article 1 of the same regulation has a very wide definition of economic resources. It's defined as assets of every kind, tangible or intangible, movable or immovable, which are not funds, but may be used to obtain funds, goods, or services. The territorial application is also very wide. Article 17 applies within the territory of the Union and to any legal person, entity, or body in respect of which any business is done in whole or in part within the European Union. And then the regulations provide for a range of derogations in certain circumstances. So Article 5 allows for derogations in respect of funds to satisfy judgments or arbitral awards. Article 6, derogations in respect of satisfaction of contractual obligations that predate the coming into effect of the sanctions regime. And Article 6b has an important provision in relation to funds that are necessary to terminate pre-existing contractual obligations. And one that's of very significant importance for lawyers is Article 4 of 269, which provides for derogations for basic needs and legal expenses. Article 4.1b allows for a derogation in respect of funds intended exclusively for the payment of reasonable professional fees or reimbursement of incurred expenses associated with the provision of legal services. And that word legal services is important because I'll come back to this in a few minutes, because the conditions surrounding that derogation have changed recently, and lawyers need to be aware of this if they interact in any way with sanctions cases or sanctions issues. And there's also in the European rules a positive obligation to provide information about knowledge of any breaches. Article 8.1 says, and without prejudice to rules relating to reporting and professional secrecy, persons must immediately supply any information which will facilitate compliance with the regulations to the competent authority in each member state. These provisions, of course, as we know, are binding as a matter of law on any natural or legal person in the member states. As all EU regulations have the force of law, their provisions are directly applicable. But enforcement is a matter for the individual member states. And all the regulations have a provision like member states shall lay down the rules on penalties applicable to infringements and shall take all necessary measures to ensure that they are implemented. And this means that member states use their own legislation to put in place supporting measures or to translate the regulations into measures that can be directly enforced in national law. For example, in Ireland, where I practice primarily, summary and indictable offences are created by way of statutory instrument, and designated competent authorities are set up in primary legislation. So in every case where there's a sanctions issue, lawyers need to check to see whether they need to obtain licenses from individual member states. But, and I'll come back to this maybe a bit later on, in order to obtain a license, you have to disclose certain information about the work of the case. And that's something that can conflict with what Europeans call the duty of professional secrecy or privilege to common lawyers. And even though there's a reference in the derogation provision to the prejudice or without prejudice to those rules, it's an issue that has been agitating lawyers and lawyers' representatives since the sanctions regimes were introduced. In July this year, the Council adopted a decision amending Regulation 833, that's the sectoral regulation. It has certainly assuaged some of the concerns about arbitral institutions and practitioners, because it provides for a clarification in relation to the exemption or derogation in relation to transactions, and it allows an exemption from the prohibition to enter into transactions with Russian entities in order to ensure access to judicial, administrative, or arbitral proceedings. So the transactional prohibition does not now extend to those necessary to ensure access to arbitration and arbitration disputes. As 2022 has gone on, the EU has adopted a wider range of measures. In October, the Council agreed to extend the prohibition of services generally to include architectural engineering services, IT services, and very importantly, legal advisory services. So it's now prohibited to provide, directly or indirectly, legal advice to persons, entities, or bodies established in Russia. And here, legal advisory services covers the provision of advice to customers in non-contentious matters, including commercial transactions involving the application or interpretation of law. It doesn't, of course, extend to representation before courts and arbitral tribunals. That much has previously been made clear. But even though the prohibition on the provision of legal services or legal advisory services has been carefully delineated, there is a nagging fear that it has an impact on dispute resolution itself. It does risk deterring counsel that are nationals of EU member states or are operating within the EU from providing pre-trial or pre-arbitral advice to Russian entities concerning the viability of potential claims and defenses. In the US, for example, the legal representation of sanctioned parties as plaintiffs or defendants in US litigation is covered by the general licenses issued by OFAC, but that doesn't require a specific permission, obviously, but such a US general license is not applicable to representation in international arbitration. But then just to move on to talk about arbitration and commercial transactions generally, parties seeking to extricate themselves from contractual relationships because of new sanctions need to look at the contracts carefully. Apart from obvious sanctions provisions, and remember that sanctions provisions haven't started to creep into transactions until fairly recently, for obvious reasons, there are illegality clauses or force majeure clauses that provide for a right to terminate. The specifics of these clauses are key, And whether or not they can be relied upon in the context of sanctions legislation is obviously a matter of contractual interpretation and the particular wording used. Some clauses refer to sanctions as a force majeure event, others specifically exclude it. Some force majeure clauses use broader language, and the different types of events specified in the clause are clearly very important. Some examples, references to war, whether declared or not, and that can be important in the context of where we are at the moment, armed conflict and the threat of same, hostilities, invasion, act of a foreign enemy, military mobilization, and so on. The construction of these types of clauses was considered last month in the Court of Appeal, as many of you know, in the MUR versus RTI case, which itself bounced up from an arbitral award. I'm going to leave that case to be discussed by others, but it seems to me that the effect of it is to caution against a very narrow interpretation of those types of clauses, particularly where the effect of such clause would actually make no difference to compliance with the substantive terms. Other types of contract clauses, obviously, as I said, specific sanctions clauses. New contracts tend to contain these, or at least contracts that have been entered into since the beginning of 2022. Impediment clauses are clauses referring to compliance with or failure to comply with the law, acts of authorities, government orders, rules, regulations, or directions. In the absence of specific provisions, you have the doctrine of frustration in common law, which has an equivalent in some civil law systems. And even in the absence of clear contractual or legal termination rights, parties can still seek to terminate contracts to mitigate the risk of breaching sanctions legislation, given that there might be stringent penalties that follow. Also, under the New York Convention, a national court can refuse to enforce an arbitral award, where to do so would be contrary to public policy. Sanctions legislation is, of course, public policy, so EU sanctions are international public policy, and a national court can refuse to recognize and enforce an award on that basis. And there's been a number of cases in recent years in various jurisdictions, and I can come back to this maybe a little bit later if I get a chance. Practical difficulties also arise in enforcing an award against a party which is subject to an asset freeze or blocking sanctions. The possibility of applying to the authorities to release frozen funds to satisfy judgments or awards has previously been discussed by the English courts in relation to Syrian sanctions. Any license application might only be permitted where certain limited exceptions apply under the regulations and would be subject to certain conditions and a consideration, obviously, by the authorities of the relevant facts. There are also potential jurisdictional issues. A good example of this is the 2020 amendment to the Russian Arbitration Procedure Code, the so-called Lugovoy Act, which took effect in Russia in June 2020. And that's a provision that allows Russian state courts, despite any existing arbitration agreements, to review on the merits any cases involving Russian parties on lists of sanctioned companies and individuals. The effect of it is that the Russian commercial courts can claim exclusive jurisdiction over disputes involving sanctioned entities or even non-Russian entities which become subject to Russian-related sanctions. It allows a Russian entity to commence proceedings before the Russian courts, or if arbitration proceedings have already been commenced abroad, the Russian entity can apply for an anti-suit injunction. No surprise to hear that this is happening quite a lot. It means that an arbitration agreement entered into by a Russian sanctioned party providing for arbitration with a seat in a sanctioning country is potentially unenforceable in Russia. Obviously, the question of its enforceability in Russia would be a hot topic anyway, even if this wasn't the case. And I suppose it's arguable that it would be highly unlikely, although the Russian Federation has publicly stated that it continues to recognize LCIA and ICC awards, whether or not in practical terms that works or not. And then just finally, I want to say something about the practical issues for lawyers. Obviously, the most important thing for all of us is the payment of fees. All of the EU measures recognize that those whose assets are frozen are entitled to legal representation. An express provision is made for the unfreezing and payment of funds in respect of legal expenses, as I said. But navigating this area presents an urgent challenge for lawyers. The position with regard to banks offers a warning. Payment for counsel can become a problem because international banks often regard it as too risky to make payments. Even though Regulation 269 does not prohibit the use of funds for the payment for legal services, in practical terms, banks often refuse to make or significantly delay such payments. In the United States, for example, banks need a separate special permission from the regulator in order to make payments, whether it's payments to a lawyer or payments to a party that has succeeded in benefiting from an award. Compliance issues also arise for lawyers in a number of areas. So there are a number of alternative possibilities. If you're giving general legal advice to sanctioned entities or entities connected with sanctions parties, even, for example, advice about a possible dispute, it seems fairly clear from the October measures in the EU that this is largely prohibited. Next, you have legal advice and representations about challenges to sanctions designation. Admittedly, not an area that's directly relevant to arbitration. And here the European legal professional representatives have engaged with the Commission to get clarity that the derogations are available to make those challenges. They're generally challenges brought in the General Court about the actual inclusion of a person or entity on a sanctions list, effectively a form of judicial review. Then there's a scenario where the lawyer is instructed to advise and act as counsel in an arbitration. Here things get a bit more tricky, as derogation licenses need to be obtained from competent authorities in different member states. The national rules vary. In Ireland, for example, the authorities have proven to be more flexible or more practitioner friendly than in other jurisdictions. But again, I should caveat that this was the position before the EU changed the rules in October and added legal services in a general sense to the list of prohibited activities. And finally, there's the scenario where the lawyer sits as an arbitrator. Here again, the best advice is to ensure that whatever licenses are needed are obtained, depending on what is the governing law and seat of the arbitration. It's not simply a self-protection mechanism, it's also important to the issue of fee payment. Whether the arbitration is administered by an institution may also be relevant, as for example, the ICC and the LCIA have secured general derogations to administer arbitrations in the UK, and the ICC has a similar license in Paris. The extent to which this will actually protect individual members of a tribunal remains to be seen. And just maybe to illustrate how complicated this can get, I'll give you one example. I'm currently involved in a case for a Spanish client. It has an agreement for the supply of metal with a German company. Two shareholders in the German company, effectively the majority shareholding, are on the list of Russian individuals sanctioned both by the EU and the UK. The German company has a wholly owned subsidiary established in Ireland, which handles the contractual payments. In other words, it's the mark. It in turn operates bank accounts in Switzerland and Austria. The contract contains a fairly standard force majeure clause. The governing law is England and Wales, and there is an ICC arbitration clause with London chosen as the seat. Now, that's not that unusual a set of facts. So now I know why a former Chief Justice here told me that a degree in mathematics is a useful thing for a lawyer to have. And so that ends my whistle-stop analysis of the EU regime. And as I said, I can expand on some of these issues in the context of a Q&A later. I'll hand you back to Andrew, and thank you again.
Well, thank you very much, Paul, for that magnificent whistle-stop tour, comprehensive of all the issues that are likely to interest our guests this morning. So, as indicated, I'm going to travel south and east now and ask Stephen to let you have his impressions of the effect of sanctions in the area where he practices. Stephen.
Well, thank you, Andrew, for that kind introduction. Ladies and gentlemen, a very good evening from Australia. It's a great pleasure to speak to you all this evening. The world is seeing the increasing imposition of economic sanctions and financial penalties applied by one or more countries against a targeted state, group, or individuals. These instruments of foreign policy are designed to apply maximum economic pressure to obtain a desired financial or political outcome. In a sea full of sanctions, we arbitration lawyers have to navigate a course to avoid any hurdles or pitfalls that would put in jeopardy the successful enforcement of the award. This is our prime objective as counsel. The impact of sanctions in international arbitration is certainly not a new issue. However, the increase in the scale and type of sanction imposed on potential parties, arbitrators and lawyers and others involved in the international arbitration proceedings have raised many questions and generated significant uncertainty over the proceedings themselves, and more importantly, over the easy enforceability of awards. These days, sanctions are involving the larger economies of the world, and there is simply more scope for more of us to be impacted by one sanction or another in the course of our practice. The impact of sanctions on international arbitration has been studied and discussed for many years, notably in relation to sanctions against Russia, Iraq, Libya, and Iran. Economic measures imposed by states unilaterally do not generate any binding obligation in the target state, in contrast with sanctions imposed by the UN. The Security Council is vested with the power to adopt the relevant measures. Sanctions imposed by the UN Security Council, according to Articles 25 and 41 of the UN Charter, create international legal obligations for every UN member state. In fact, a breach of these sanctions under the UN Charter can amount to a violation of public policy under Article 5 of the New York Convention. Where sanctions are adopted by regional international organizations, such as the EU, or by a single state, the provisions are binding only on natural legal persons under the jurisdiction of the state enacting the sanctions. Correctly identifying those bound to comply may present difficulties. Sanctions are territorial. They are informed by political realities, and one sees a trend towards an increase in the use of unilateral sanctions. In the case of the 2014 and 2022 Ukrainian crisis, due to Russia's Security Council permanent member status, multilateral sanctions against Russia were not possible. The application of economic sanctions imposed, for example, unilaterally by the US, UK, EU, and the rest of the world upon Russia in relation to the situation in Ukraine are territorial. They apply within the sanctioning territories to any person who is a national of a state or incorporated under the law of a state, or to any legal person in respect of business done within the jurisdiction of the sanctioning state. Other entities not listed in the sanction have no obligation to adhere to the restrictions it imposes. These considerations can indeed influence parties opting for arbitration instead of court proceedings, as well as the selection of a particular seat which may be used to try and avoid the application of sanctions. Of course, the tribunal will have different considerations depending on whether the sanctions arise from the substantive law governing the dispute, or the state where the arbitration is seated, or a third state with a sufficiently close connection to the dispute. Although arbitral tribunals may have considerable freedom in deciding whether to give effect to sanctions, there is the risk of challenge in the seat or in the place of enforcement, which may render the choice of arbitration seat moot. It is important to recall that arbitration inevitably involves a personal dimension. Arbitrators, counsel, and the administrative personnel of the arbitral institutions are private individuals who must comply with all of the laws of the state of their residence and may indeed face significant administrative and criminal penalties for non-compliance. Therefore, sanctions will have a significant impact on proceedings if they relate to the individuals acting as arbitrator, acting as counsel in arbitration, or acting as legal expert, or acting in an administrative capacity in arbitration proceedings. Also, at the forefront of any good arbitrator's mind is to do all they can to ensure an enforceable award at the end of the day. From an arbitrator's perspective, deciding on the impact and effect of any set of sanctions, their scope and applicability, any inconsistent laws or regulations, or overriding mandatory rules in any jurisdiction can present real complexity. It also can present real uncertainty. A tribunal will usually have to consider this parallel existence of various applicable laws, the substantive law applicable to the commercial relations between the parties, the lex arbitrae, the laws of any state where the winning party might seek enforcement of any arbitral award, other laws with which the dispute has a significant connection, and how any sanctions, their scope and applicability, impact on all of the above. A very complex task indeed. Complexity and certainty do not often sit too well together. The appointment of arbitrators is principally a personal appointment, where the characteristics of the individual will play a significant role in the appointment process. A sanctioned individual would cause concern over the legitimacy of the proceedings and the ultimate enforcement of the award. Most likely, sanctioned arbitrators will not be appointed, or if already appointed, they will be subject to challenge. And if necessary, if those challenges are unsuccessful, they will be subject to challenge and further challenges post-award in the seat and in the place of enforcement. The primary purpose of arbitration is to obtain a good quality award, which you can easily and quickly enforce. Anything that challenges this fundamental principle of arbitration, which is the backbone of the success of international arbitration, must be prevented at all costs. Inevitably, ladies and gentlemen, much of the anxiety around the application of sanctions in international arbitration arises from the possibility that an award is tainted by sanction and might be set aside, or its enforcement might be ultimately refused by competent national courts. The grounds for intervention of the court are limited. It's provided in the New York Convention 1958 in the model law, for example, although public policy features significantly. Article 5 of the New York Convention defines the grounds to refuse enforcement of foreign arbitral awards, and these are uniform across all signatories to the convention. There is little current guidance as to whether economic sanctions constitute part of the public policy of an enforcing state, and if so, whether they outweigh the enforcing state's policy in favor of the finality and enforceability of arbitral awards. It's worthy of note that the International Chamber of the Paris Court of Appeal in 2020 dealt with the impact of US, UN, and EU economic international sanctions against Iran on the validity of an arbitral award in a decision dated the 3rd of June 2020. The case is called SAT against N, rejecting the application to set aside the award. The French court found that the unilateral sanctions do not fall under the qualification of French international public policy. The case does draw a clear distinction between unilateral sanctions and those imposed by UN Security Council resolutions when it comes to considerations of public policy. However, the uncertainty surrounding the impact of sanctions more broadly on the validity of awards remains. Further issues also arise due to the blocking or freezing of any payments to or from a sanctioned entity, potentially preventing the payment of arbitration fees, arbitrators' fees, the fees of counsel, the costs of witnesses, and most worryingly of all, potentially preventing payments as a consequence of any arbitration award. The increase in US, UK, and EU sanctions, including against Russia, and EU sanctions, including against Chinese officials, and China's counter-sanctions against a number of British individuals and entities have created hurdles which arbitration practitioners have to overcome in order to ensure the enforceability of the award. One of the most significant sanction developments is the impact of sanctions against members of the bar and sets of barristers' chambers, who may be participating in existing or future arbitrations, either as counsel or arbitrator. In March 2021, for the first time, an issue of explicit concern to the arbitral community arose following the imposition of sanctions known as the 263 sanction by the Ministry of Foreign Affairs of the People's Republic of China on individuals and entities, including a London set of barristers' Essex Court chambers. The sanction by the Chinese government affecting legal professions including arbitral practitioners, sets a very worrying precedent. The 263 sanction would appear to be on all of Essex Court as a whole, and was apparently attributed to an opinion produced by 4 barristers from Essex Court concerning the treatment of the Uyghur population, which was then posted onto the website of the Chambers, to which the People's Republic of China took exception. In the UK, as we all know, unlike a law firm which has its own legal personality, a barrister's chambers has no legal personality of its own. A barrister's chambers is simply a collection of individual self-employed barristers independently operating under one brand. The 263 sanction, which I've just mentioned, is very broad. It states, as of today, the individuals concerned and their immediate family members are prohibited from entering the mainland, Hong Kong, and Macau of China. Their property in China will be frozen, and Chinese citizens and institutions will be prohibited from doing business with them. The 263 sanction is widely regarded as a sanction that has been imposed on all barristers who are members of that chambers on that date, the 26th of March, 2021, these being sanctioned individuals. As Lord Neuberger said last year in the SIR annual lecture, he said the 263 sanction appears to have a broad reach as doing business and was presumably intended to have a wide meaning. And he goes on to say, and there may be room for doubt whether some institutions, in particular the Singapore International Arbitration Centre, or even more, the Hong Kong International Arbitration Centre, would want to be responsible for administering arbitrations with a targeted person on the arbitral panel. According to the 263 sanctions, Chinese citizens and institutions are legally prohibited from doing business with sanctioned individuals. This means that Chinese law firms are not entitled to appoint any sanctioned individual as arbitrator or as counsel. To do so would mean that both the Chinese law firm as well as the Chinese client would be in breach of the 263 sanction. There is also an additional concern. If any of us propose a sanctioned individual to act as arbitrator or counsel, and problems arise due to these sanctions, are we professionally negligent for making such a suggestion in the first place? Sanctions create legal uncertainty, legal unpredictability, and this must be avoided. In order to ensure enforceability of any award, it can be simply expressed. Those subject to sanctions cannot safely participate in arbitrations, whether as counsel or arbitrator or in other capacities, until those sanctions are lifted. Sanctions create many complex and practical difficulties for we arbitration practitioners, which we require to address until those sanctions are lifted. We all need to consider the applicability of sanctions right at the start of any dispute, and certainly right at the beginning of any arbitration. Then we need to consider how best to navigate a course through these sanctions. Thankfully, ladies and gentlemen, the lifting of sanctions is a task for the politicians, not the lawyers. Thank you, ladies and gentlemen.
Thank you very much, Stephen, for that insight. We're going to come back now towards the UK, and I'm going to ask Daniel to deliver his piece for us. Thank you, Daniel.
Wonderful. Thank you, Andrew, and thanks to Six Pump Court for the chance to join such a distinguished panel. I'm going to cover the UK position. I've got 6 broad points to make in the next 15 to 20 minutes or so, but I thought it was worth just taking a little step backwards first and just thinking about sanctions generally. So I've been doing sanctions work since about 2010, predominantly Iran related, Syria, North Korea. And there was a time it was a relatively sleepy backwater. I could do the work I was doing in relative peace. Our clients are predominantly shipping and trade clients, and therefore they will trade to exotic jurisdictions, and therefore we needed to help them with DRC or Cote d'Ivoire jurisdictions like that. And obviously the focus now on Russia is bringing an awful lot more attention onto these issues, but also bringing their impacts to bear on an awful lot more people. But taking a step back, I think it's worth making the point that trade sanctions are a particularly peculiar creation for two main reasons. The first one I'd focus on is essentially the question, what are they? Because sometimes when I present on this, I have a Venn diagram and I have sort of politics at the top of the chart, then I have trade, and then I have law. And sanctions are very much in the center of that Venn diagram, because these are politically motivated tools intended to change behavior or to signal distaste for a particular course of behavior. And that is where we start, is with the politics. They then derive their force by restricting commercial activity. So whether it's lawyers on the call who want to practice legal advisory services, whether it's arbitrators sitting as arbitrators, indeed experts, whoever it might be, what the sanctions do is stop that ability, or at least restrict that ability, to operate in a commercial context in order to achieve that political objective. And then finally, we come to the legal instrument, which, as a gathering of lawyers, I can complain about the poor quality of the drafting in a friendly crowd. But it is certainly the case that here we see measures which are introduced often at speed, and often in cases in which the legal drafting may leave something to be desired. So a good example is where we are at the moment with the Russia measures. The G7 prohibition on transporting Russian oil came into effect today. And it was only over the weekend that we saw guidance issues, that we saw general licenses issued. So that whole framework that needed to come into play because of the political piece and because it restricts trade, then getting the legal piece in place became a real challenge and very much a last minute development. So I think that aspect of it, in terms of understanding where they come from, is really important. And also, to pick up a point that Stephen made, what that also means is that they will evolve over time. This isn't like, say, the Bribery Act or Modern Slavery Act, where you can review the legislation once and understand the shape of it. The legislation is changing over time. We will at some point see sanctions lifted, but also the status of the sorts of individuals and entities that Paul and Stephen have talked about as being the target of sanctions will change over time. So importantly, for those who are acting for entities or individuals who may become designated or sitting as arbitrators and potentially issuing awards, their status will change over time. So this isn't a static issue. The law changes and the factual piece changes. Second point to make, and this sort of comes into points I was going to make later, but importantly, whereas the majority of the work that we as commercial practitioners do will lead to civil consequences, will lead to claims and counterclaims between parties, sanctions violation is a criminal offence, certainly from a UK perspective. And therefore there is scope for those who breach sanctions to face imprisonment and potentially unlimited fines. So that combination of rapidly evolving, potentially poorly drafted and not fixed over time, plus this enormous sledgehammer in the event you get it wrong, really should cause people to pause and to consider these are very significant measures. So enough of the background. What I thought I'd cover in terms of my 6 topics, I'll look at the UK framework, where things come from, look at where we are in terms of UK enforcement, identify the prohibitions that apply, and then look at some of the issues in terms of where we've got support to help us. Following the UK's departure from the European Union, the UK has an autonomous sanctions regime. And therefore, while we see significant overlap between UK measures and EU measures of the kind Paul was talking about, they are different. Where we got to immediately after the UK left the European Union was that there were legislation adopted which is intended to align the UK with the EU position. Essentially, we set the EU position in ASPIC, recodified it as UK instruments, and therefore on the first days after the UK left, the position should have been the same. But there is, of course, the potential for divergence over time. For a purely legal framework, the UK adopts sanctions through 2 main methods, or through 2 main instruments, really. The primary legislation is the Sanctions and Money Laundering Act 2019. So that's Act of Parliament. It sets out the legal framework that sets out the basis for UK sanctions. What the UK then does is for each of the different sanctions programs, so whether we're talking about Russia or North Korea or Ivory Coast, Afghanistan, there are separate UK statutory instruments, so secondary legislation, that set out the specifics of the particular restrictions. So in the case of Russia, we have a set of regulations from 2019. So I gave you 2019 as the SAMLA date, so SAMLA is 2018, sorry, my fault. But the Russia regs are 2019. But what we see is that, and going back to my point about change, is that the 2019 regulations have now been amended on multiple occasions. I've lost track slightly as to whether up to Amendment 16 or 17, but in essence, as new restrictions are imposed, there are amendments made to the initial regulation. So anyone who's looking to understand the current scope of the UK regulations needs to be looking at SAMLA in terms of the architecture and the overall approach. You need to look at the Russia regulations, but you need to have identified all the amendments to the Russia regulations because they will add and subtract as they go along. And we'll come back to why that matters when we look at some of the restrictions. As I said before, in terms of enforcement, breach of sanctions is a criminal offence, but also what we are increasingly seeing and have probably seen most large of the past 3 to 5 years, I suppose, is that the UK looks to the US in terms of an approach to sanctions. We've seen significant historic US sanctions enforcement, and the UK is looking to do something similar. So because of the difficulty in securing a criminal prosecution, it is made easier for the UK in two main respects. Firstly, the UK regulator, the Office of Financial Sanctions Implementation, or OFSI or OFSI, are able to impose civil monetary penalties, and therefore the burden of proof and the threshold to make out those offences is a civil standard rather than a criminal standard. And they can impose penalties up to 50% of the value of the breach, or £1 million, whichever is the greater. So again, very significant penalties there. The UK has also codified prohibitions, which from an EU perspective will have a knowledge element, in other words, that the party knew or had reasonable cause to suspect that what they were doing would infringe the sanctions. And while that language still appears in the UK offences, power is given to OFSI to enforce the measures as if that element was not included. So from a lay perspective, you would say that's essentially strict liability. So from a UK perspective, as opposed to an EU perspective, sanctions can be breached on a strict liability basis. But I think also, and I think Paul touched on this as well, importantly, in addition to those enforcement powers given to the regulators, there will be practical consequences of a sanctions violation. So Paul mentioned banks and the unwillingness of banks to process payments where there's any concern around sanctions issues. Likewise, from a professional perspective, understanding the position of PII insurers and other insurers that an organisation relies upon, understanding clients' viewpoints and the reputational issues. I'll come on in a minute to recent guidance issued by the SRA in the UK, but it's striking that in a number of places the SRA is talking to law firms about the need to weigh up the reputational issues in addition to the legal issues in deciding whether or not to proceed. So bearing in mind that sort of the practical consequences. And I think also importantly, there's an internal issue in terms of firms, or in terms of sets, or in terms of arbitral bodies, willingness to take on those reputational issues, and they are significant. Where we've got to in terms of actual enforcement is that we have seen a number of instances of the UK seeking to enforce financial sanctions. So a couple of recent examples are TracerCo and also Hong Kong International Wine. So these are two cases of the UK seeking to enforce. The cases are significant, not necessarily because of the raw amount of the fine or the settlement that was imposed in terms of the numbers, but more from the perspective that it shows the UK looking to use its civil monetary penalty powers. But also, these are not necessarily cases in which there's a compelling public interest in enforcement. So in TracerCo, for example, in that case, TracerCo is a UK engineering company. They made a payment via travel agent to a sanctioned Syrian airline in order to fly one of their employees back to the UK. And therefore, if you were instructed, and if you're contesting the enforcement case, you would be able to make out a reasonable argument, it seems to me, but actually there isn't a public policy there in enforcement, because the policy in repatriating that individual should be weighed equally heavily. So my point really is that given that history, I think we can expect to see OFSI enforcing in a number of cases where that meets the enforcement criteria. So in terms of the scope of the sanctions, whether we look at Iran or Syria or North Korea or any of the other jurisdictions, there are a range of different prohibitions that are applied, and they will overlap and operate in parallel. Therefore, where we've got multiple restrictions in place, a violation of any of those restrictions can trigger the enforcement. It's not necessary to trigger all of them. For the purposes of this morning or this afternoon, wherever you are, two key restrictions from a UK perspective. The first is the asset freeze, and Paul and Stephen have talked to that, but also a prohibition on the supply of legal services. The way the asset freeze operates essentially has two elements. Individuals and entities are listed, and then in terms of the first element, their funds and economic resources are frozen. So if I am a Russian oligarch and I become added to the UK sanctions list, funds that I hold within UK financial institutions will be frozen. But importantly, and probably more relevant for us, it is also prohibited to make funds or economic resources available either directly or indirectly to that sanctioned person. Now, coming back to this distinction that I talked about between SAMLA as the overarching architecture and the regulations, when we come to terms like economic resources, those are defined in SAMLA rather than the Russia regulations. So section 60 of SAMLA, so the Sanctions and Money Laundering Act 2018, defines economic resources, and it's defined as assets of every kind, whether tangible or intangible, movable or immovable, which are not funds, but can be used to obtain funds, goods, or services. So given that broad definition, questions I think have to arise as to whether an award itself, given it can be recognized and it can be enforced, would that be an economic resource? Is that an intangible asset that can be used to obtain funds? I think it's certainly arguable that it might, and therefore from the perspective of arbitrators, another reason to understand both the status of the parties and the risk that their status may change over time. The other prohibition that I wanted to talk to is prohibition on the supply of legal services itself. Now, I think the position is complex, so bear with me as I go through it. Essentially, the UK position is that historically the supply of legal services, even to a sanctioned person, would not itself be prohibited. So just reading from UK sanctions guidance from August 22, this says, generally you won't be prohibited from providing legal advice under an asset freeze. However, the payment for legal services and the provision of legal services on credit do require an OFSI license. So essentially that was the previous position. On the UK, getting paid by a sanctions target would need a license, but providing legal services of themselves would not. That said, there's a comment in the guidance around making sure that legal services are not being used to circumvent other prohibitions. But putting that to one side, that is where we were. What has changed, and I think it's fair to say the position is evolving, is that on the 30th of September of this year, the UK announced that a prohibition would be imposed on the provision of legal advisory services to Russian entities, mirroring the points that Paul was talking about from an EU perspective. Now, again, coming back to my personal hobby horse about lack of certainty, we therefore, as UK practitioners, are in a position where we've known for more than 2 months that legal services are going to be prohibited, but the instrument has not been published, and therefore currently there is no legal prohibition on the supply of legal services. But it will come, or at least it's being said that it will come. I think I saw comments from OFSI a week or two ago that prohibition will be introduced either towards the end of this year or early next, and therefore that will change. But that is overlapping with the position on the asset freeze. Where we've also got to, in terms of the UK restrictions, is that there's now a general license in place issued in the context of Russia that authorizes the payment of legal fees by designated persons in the context of Russia subject to certain conditions. And it is a complex general license. It's split into two parts, and there are financial limits, and there are limits on rates that can be charged, and limits on expenses and points like that. So it's complicated, but there is that general license in place there. There's also a general license that was obtained by the LCIA that enables the supply of services under arbitrations in that context. Final couple of minutes from me. The other thing, and sort of coming back to this question of how the landscape is evolving with respect to the supply of legal services, and then I'll come back to a focus on managing risk for lawyers and arbitrators. What we also saw on a week or so ago is the SRA has now issued its guidance to lawyers. So that was issued on the 28th of November, 2022. It runs to about 28 pages. I think it's quite detailed. But there are a number of things that seems to me to be striking in reading through it. I think there are a number of comments in that paper which almost indicate that the SRA takes a different view on the lawfulness of the supply of legal services. It doesn't quite go so far as to say you cannot, but it also doesn't include wording that is as clear as the OFSI guidance that I just read out is, that you can do it. So therefore query where that's moving. There are also a number of significant warnings to law firms around the challenge and the complexity of the work in this area. And I can't remember having seen SRA guidance before, which in any field, which says, it essentially says to practitioners, you shouldn't do this work unless you really, really do this work. So it talks about the requirement to ensure that those who are doing the work have the necessary skills and expertise to do it. So I read those 2 points in conjunction as the SRA saying to the industry, these are significant issues, they are difficult, and almost you should err on the side of caution and not do this work, even if you think you might be able to do it, rather than not do it. Which sort of takes us into the broader restraint on trade elements of sanctions, and the fact that we see in a commercial context many clients choosing to self-sanction and not engage in activities because they're concerned that they might get it wrong. Other thing to say, and I'll sort of close, is that one of the questions that I get asked a lot by clients in the context of their processes and procedures, and certainly the SRA focuses on the requirement to have those policies and procedures, is that the main way to mitigate the risk of dealing with a sanctions target is through due diligence. And we can talk separately about whether that still applies even if there's strict liability. But in essence, the point here is that, and sort of talk about it through the lens of the SRA point, what they are saying is that if we start with lawyers, lawyers should be conducting enhanced due diligence on their clients to ensure the client is not on a sanctions list. But that's not just limited to the named entity you're dealing with. It will extend to individuals or entities who own or control that entity, because the effect of the asset freeze, whether from Paul or Stephen or my perspective, is that not only are the named individuals and entities targeted, but also those who own or control them. So you can be in a position in which, notwithstanding that the entity you're dealing with is not on a list, they will be treated as if they were on a list. And again, personal hobby horse on legal certainty and knowing the law, and I don't think that's how it should operate, but that's a debate for another day and perhaps a stiff drink. But importantly, having made that point that you need to check everyone, what the SRA guidance also says is you cannot rely on third parties to do that checking for you. So whether that's lawyers relying on, say, insurers who are instructing them to have done DD on the policyholder, can't be done, lawyers have to do their own DD. Whether it's counsel then saying, well, instructing solicitors have surely checked these entities, can't I just rely on instructing solicitors? Answer no. Arbitrators saying, well, the parties have surely checked them, can't I just rely on the parties, or do as an arbitrator need to check? Again, answer no. So that's where we get to sort of recap, is concerns around the asset freeze, doing the DD, keeping it up to date, but also keeping an eye on this evolving landscape with respect to the UK prohibition on legal services, and sort of watching for more OFSI enforcement. That's the stop for me. Thank you.
Thank you very much indeed, Daniel. It's somewhat terrifying to listen to you and consider what is in prospect for us all. Now, we have some questions, and the audience can use, as I said before, the question and answer tool on the Zoom platform. A couple to start with, I think, Paul, that I will address to you, since you raised these matters, and that now people are seeking your views in relation to them. So the first question is, does the obligation to provide information to regulators when seeking a derogation or license to act conflict with ethical obligations to the client? Your view, please.
Yes, I suppose I did refer to this briefly. It depends a little bit on where you are in reality. Some regulators look for more information when they're giving you permission or a license, as it's known, by way of derogation from the EU measures. Although the EU regulations specifically say that the obligation, the derogations are without prejudice to obligations of, for example, professional secrecy and so on, there has been a concern in certain parts of the world that the regulators are looking for too much information. It's very much a kind of a chicken and egg situation. You can't get permission to act or appear unless you provide some information about what you're doing as a matter of fact. And by providing that information, you therefore disclose to the regulator or the competent authority some information about the dispute, which might give rise to a further investigation or inquiry about the individuals concerned. In Ireland, I know our regulators in providing for derogations for lawyers have been relatively relaxed about this. They don't tend to inquire too much for the moment. I don't know what the position is in other member states. I've heard that in France it's a little bit more difficult. The United States obviously is a different jurisdiction, but they certainly have taken the view that they won't give permissions without quite a lot of information being provided. And I know that the American Bar Association has been agitating about this issue because there is a clear conflict there between ethical professional secrecy rules and what's required in order to get a license.
Do you envisage, Paul, a follow-up question, if I may, of my own? You envisage that we're going to get into situations where clients are complaining of breaches of obligations of confidentiality, and the defense that's going to be run is, well, I was asked, I was required to do this in order to get my license to represent the client. And where does the regulator stand when that situation arises?
Yeah, I mean, I agree, Andrew. I mean, I think a lot of it, obviously, you can be cynical about it and say, well, look, I mean, you're talking about an entity which is already the subject of, and this only arises in circumstances where you're concerned about the possibility of the application of the rules to your client. But obviously, you need to look down the line and see, well, look, what happens if, for example, it turns out that they weren't correctly sanctioned? Or what happens, for example, is if they are able to avoid the sanction in the context of the specific dispute that arises. But nonetheless, information that you have disclosed in order to get permission to represent them has, if you like, awakened regulators to some other issue that gives rise to further penalty on them. I mean, I know it's a bit of a long shot, but obviously as lawyers, we're used to making sure that we cross every T and dot every I for the purposes of our own compliance. So it's a very complex area, and it needs to be looked at on a case-by-case basis, I think.
Yeah, that's very helpful. I don't know whether, Daniel, you wish to add anything to that, since you looked specifically at the SRA guidance, and I detected not a great deal of contentment with it as it stands.
I think that's fair. I mean, I think it might be worth reading it. I'm going to try and read the paragraph as neutrally as I can without disclosing my own views, but I will struggle. So the UK position is where Ofsted asks for information, for example, in relation to a license application that would rightly be subject to legal professional privilege, and that privilege has not been waived, you cannot volunteer it. So helpful to that point. LPP essentially preeminent. But then it goes on to say, and this is where I come out more jaded, however, in such an instance, Ofsted is under no obligation to grant a license without this information. This is a risk you should consider when deciding to work in the sanctions area. So essentially, you must comply with the LPP and not waive client's privilege, but you can't get a license for which you need to act. And well, terribly sorry, that's a risk you run. I won't say more than that. I've probably said enough, but I find it very unsatisfactory.
Pretty clear where you're coming from, I think, to those listening. So another question, Paul, if I can come back to you, that touches on something that you dealt with. Again, they're asking you for a view and an answer on this point. And it is a direct question. Can the concept of public policy, NYC, New York Convention, be used as a defense to enforcement where there is an award connected with a sanctioned entity? Are you prepared to stick your neck out?
Yeah. Again, I mean, there's been quite a lot of discussion in this area, and there have been some cases. In 2019, the High Court in England held that the sanctions against Iran prevented its Ministry of Defence from enforcing part of an arbitral award on public policy grounds. And there have been cases in the US, although there's a famous case from 2011 in relation to sulfuric acid produced in Iran and destined for Venezuela. And the US Southern District of New York actually enforced an award and distinguished between what it described as public policy and national policy. It said that there is clearly a national policy in the US to discourage trade with Iran, but public policy and national policy are not the same thing. And foreign policy disputes with another country isn't enough to overcome the obligation or the supranational policy of providing for, and this is a great phrase that they use, predictable enforcement of international arbitral awards. So as arbitration practitioners, we're delighted to see words like that being used by a court of such standing as the federal court for the US Southern District of New York. So I suppose the answer to the question probably is it depends on who's looking to avoid enforcement. What you've often seen is, there's a case, another US case from earlier, where Aeroflot sought to avoid enforcement of an arbitral award on the grounds that it breached policy in relation to trade in a particular area. And the US court said, no, the Aeroflot hadn't persuaded it that it could avoid it. And in effect, Aeroflot was trying to avoid enforcement on public policy grounds against it, on the grounds that it was engaged in activity that was contrary to public policy. So the US court said, no, don't be daft, that's not going to work. So, I mean, I suppose the answer is it does depend a lot, but I think there's a lot of scope for using the public policy ground in order to do that. There's just one other thing that I wanted to mention before I stop, and I'm sorry for taking up time. And that is, there is an unusual provision in it relates more to the question of force majeure and contractual disputes. There is a provision, I'm not sure whether it's the same in the UK, but there's a provision in the EU regulations which shifts the burden of proof on parties that are seeking to avoid enforcement. It's in Article 11 of Regulation 269, which changes the burden of proof from what we in the common law would normally expect it to be. So it says there the burden of proof is on the party relying on force majeure, not on the other party. So in other words, if somebody is seeking to try to avoid on that basis, then that shifts the burden of proof. And I'm not sure whether that's the same in England and Wales or not, but I mean, that's perhaps a discussion for another day.
Very well, thank you for that. Paul, you're obviously a low fay with this area, though it's not easy to give a simple, straightforward answer to the question that we have been considering. So I'll keep in the same order, picking out questions that seem appropriate to the topics you've each discussed. Stephen, you mentioned institutions in the course of your talk. This question has arisen. Do you consider there's sufficient institutional guidance, support, and protection of arbitrators in relation to their exposure to risk of falling foul of absolute liability and penalties for unwitting breach of sanctions? And if not, should arbitrators be considering the sanction situation on their own initiative, and how?
I think the answer to your question is yes, there's insufficient guidance. And what I think we should all do, because we all have a stake in this. The clients have a stake the council, we have a stake in making sure that there's an award which can be enforced and is unlikely or less likely to be subject to challenge. And the arbitrators also have a stake. They want to make sure that the award which they eventually draft is unchallenged and also capable of enforcement. So I actually think that we all have to partake in this process. And I think we should all consider the question of sanctions. And Council, if we consider there's a sanction issue, I think we should bring it to the attention of our opposition and also the tribunal. And likewise, if the tribunal, the arbitrators are of the view that there's an issue of sanction, they should bring it to the attention of the parties and Council and ask them to comment upon it. And I think if we all approach sanctions on that basis, as Daniel said, it's terrifying. I love that expression, Daniel. It's terrifying. It is terrifying. There is so much to consider, and there is so much that can go wrong for everyone involved in this process if there are sanctions creeping in and attaching to people directly or indirectly. We need to make sure that we're aware of what the situation is. So we need to think to ourselves, what are our protocols as Council, as law firms advising? What are the protocols of arbitrators? And then perhaps we should get some help from the various arbitral institutions about maybe putting together some draft protocols that tribunals can use or utilize when they are approaching the question of sanction right at the beginning of an arbitration.
Thank you for that. We've a number of questions here, not surprisingly, about the future, where things are going. I'll ask you one, Stephen, while you're in pole position, and a couple for you, Daniel, since they seem to relate more to the UK situation. You referred to the well-known Section 263 sanction imposed by the People's Republic of China, MOFCOM, I believe it's called, that authority in China. The question is, do you think we will see more sanctions, not just confined to or from China, directed at lawyers and arbitrators? What's your view on that, Stephen?
Well, I would say, Andrew, I would certainly hope not, but I fear we will see many more of these sorts of sanctions targeting lawyers and law firms and the participants, the players in the arbitral process. So I'm greatly concerned. Look at the world. You know, the world is moving away from democratic regimes to autocratic regimes. There's conflict about resources, about all sorts of things. There's economic conflict as economies grow and clash into each other. There is significant scope for sanctions to be used as economic and political tools. And I fear now the precedent has been set by China and the 263 sanctions. I fear the participants, the arbitrators, the council, the law firms, we will be next in line.
Thank you for that, Stephen. And if I can turn to you, Daniel, you've been talking about OFCE's significant enforcement powers. What's your view overall as to whether we will see greater enforcement in the UK and from Paul's point of view in EU member states? I'll ask you first, Daniel, on that.
Thanks, Andrew. So short answer, yes. I think we will see more UK enforcement. I think the rumours I'm hearing are of OFCE increasing the workforce, employing more people. I think living in straitened financial times, the cost of growing any government department will be carefully scrutinised, and therefore those people will have to demonstrate, or those who are responsible for growing that department will have to demonstrate that it was money well spent. And obviously the easiest way to do that is with cash in the coffer. We've seen it from the US, where the US enforcement against banks has run to millions and indeed billions of dollars. So I think we will. I think also, I think the climate has changed in that I think there is a large and understandable groundswell of public opinion in favor of sanctions against Russia, given the conduct. And therefore, I think there will be enforcement will be welcomed from that perspective as well. So therefore, I think it will happen. Yeah, whether it's 6 months or 12 months, but I think there'll be a significant body of enforcement.
Very helpful, thank you, Paul. Can I ask you whether you share that view as to the
I do.
things likely to happen in the EU, the way things are going to go?
Yeah, no, I do. I mean, the EU has a sort of a quasi-competitive approach being taken by the various, because as you know, enforcement is a matter for the individual member states. Obviously, I should say there is a certain political element in this as well. Competent authorities are designated by national governments, and in certain member states there has been a I won't say a slowness, but certainly the results of the enforcement measures to date are not quite as good. I don't have the exact figures, but I think in Ireland, the central bank here has moved to freeze several billion worth of euros that were held by sanctioned entities. I think the equivalent figure in a country like Hungary is very, very small, which will kind of give you an indication of what you're looking at. But because of the fact that the competent authorities are all required to cooperate with one another and the Commission, there is, as you always get with EU enforcement, a kind of a scorecard being regularly done up. So the way the Commission operates is it publishes every 6 months or thereabouts a report on the implementation of the sanctions regimes, member state by member state. And the purpose of that then is obviously to try to encourage individual member states to get better at what they're doing. Obviously, Daniel is correct. This is all a matter of national resourcing. But there doesn't seem, certainly in the bigger member states, there doesn't seem to have been any indication that they are not going to do it. And certainly that there's been quite a clamour politically in some places for lots more to be done. So I think you're going to see an awful lot more enforcement in the coming months, certainly.
Thank you very much for that, both of you. I'm going to finish with one open question, but it's in the same vein. I'll direct it to you, Paul, since we are broadcasting from the UK, if I can put it that way. It's a simple one, but interesting. If there's anything you have in mind, the question is, what's next on the horizon? Do you think? Anything you can think of?
Oh gosh, I mean, again, that I think is a question that raises a political or calls for a political consideration. I think that the European Union has shown a willingness to try, notwithstanding the differences and divergence of views that are there, to try to be as strong as it possibly can within the confines of its own constitutional structures. It is concerned that it is not seen to be behind the UK and the US in the strength that it, or in the measures that it seeks to impose, and particularly in relation to Russia. So I think you're going to see more measures like the measures that are introduced as of today with the price cap on some energy supplies, and I think that's going to be extended. I think that by the middle of next year, and I think it's all to do with the coordination that exists between the EU, the US, and the UK. And the other G7 states on this issue. So I think they're just going to keep looking for ways to impose stricter and harder sanctions. And that then trickles down, as Daniel said, to the enforcement issues, the compliance issues that affect all of us individually. So it's going to get more complicated, I think.
Thank you, Paul. Having offered you the floor, Daniel, I then gave it to Paul. Do you have anything to add to that? Apologies.
No, not at all. No, I mean, I would agree with Paul. I mean, maybe taking a sort of wider view. This is probably sufficiently we've seen sanctions in place since 432 BC, when between Megara and Athens, so it's nothing new. But I think what we have seen is politicians seeing them as a method to achieve a political objective. And therefore, I think I absolutely agree with Paul in terms of what will happen on Russia, but I think we will also see sanctions continue to be implemented in response to political events. And, you know, I would like to speculate as to where it might be next, but I don't think it's a challenge that's going to go away. I suppose the only other thing to add is that my sort of experience of looking at Iran is that at some point, and you know, there's again a conversation another time around the fact that sanctions don't embed within themselves the mechanism for lifting them. But having said that, at some point there will be some sort of progress or resolution, and we'll begin to see sanctions be lifted. I think just important to keep in mind, and as I say, sort of given the Iran experience, is that when the sanctions do come to be lifted, they will again be lifted progressively, and therefore it will be as challenging coping with what's being permitted again, as opposed as challenging as it is currently, understanding the new restrictions as they're imposed. So that wind down period is just as difficult as the ramping up period. But yes, I would agree with Paul.
Very good point, on which I think we've come to the end of our time, and I will bring the webinar to a close with my thanks to you three gentlemen for an illuminating perspective from three different standpoints. Ladies and gentlemen who have attended, I hope you have found it interesting and useful and certainly thought-provoking. Do not be terrified. You're well capable of dealing with all of these issues, but it will take time and a lot of hard work. Thank you very much for attending, everyone, and have a good day in England or a good evening if you're somewhere else. Thank you very much. I'll bring the proceedings to a close now. Goodbye to you all.